Welcome, everyone. Welcome to this podcast of ERA's 30 Years, 30 Cases series. My name is Daniel Gärtner and I'm Senior Lawyer and Course Director at the Academy of European Law in Trier, ERA. This year, 2022, ERA is celebrating its 30th anniversary. To mark this anniversary, ERA will be launching a series of video podcasts entitled 30 Years, 30 Cases throughout the year. Each of the videos will deal with one specific year from 1992 to 2022 and one landmark case of the Court of Justice of the European Union in Luxembourg. In the now following video, we will present a landmark case from 2010, case C-555/07, Seda Kücükdeveci versus Svedex GmbH & Co. KG. The Kücükdeveci case confirmed and clarified the controversial Mangold judgment from 2005 by ruling that private parties can rely on the general principle of equality as given expression in the Framework Equality Directive in order to set aside conflicting domestic rules in horizontal litigation. For this reason, the Kücükdeveci case is relevant well beyond the field of non-discrimination law, as it concerns the relationship between primacy and direct effect and the definition of the effects of EU law on individuals. And now I'm delighted to introduce the speaker who will present to you the factual background of the case, as well as the main legal questions and answers of the judgment, and also explain to you why this case was, and still is, considered such an important case in and beyond the area of non-discrimination law. It is my pleasure to introduce Professor Dagmar Schiek. Dagmar Schiek is Professor of Law and the Vice Dean for Research in the School of Law at the University College Cork. Since December 2020, she holds the Synod Family Chair in EU Law, and since September 2011, she has been a Jean Monnet ad personam Chair for EU Law. She has been a Professor of European Union Law since 2000, and coming to this position from a background as comparative labor lawyer and anti-discrimination lawyer, in which capacity she also drafted anti-discrimination legislation in Germany. I would like to sincerely thank Professor Schiek for having accepted the invitation to contribute to ERA's 30 Years, 30 Cases series by presenting the Kücükdeveci case.
So thank you for allowing me to be part of this series. I'm talking about Seda Kücükdeveci. There are really two stories to her case. One is a story of a seminal case where the interests of the claimants remain irrelevant before the court, confirming that the EU and its law are somewhat distant to the citizenry. And second, it's a seminal case on the relationship of EU law and especially the rights guaranteed by the Charter of Fundamental Rights and national law in horizontal relationships. So let's start with the facts of the case, illustrating the first element, and then go on to the legal relevance. I didn't want to treat you too many PowerPoints, but well, here's just the lead slide, where you can also see my Twitter hashtag. And then this next slide is the structure of my presentation. And now I go out of the slides again and start with the facts and context. Seda Kücükdeveci commenced employment with Svedex company as a semi-skilled worker in June 1996 when she was 18 years old. And in December 2006, she was dismissed from a part-time job, which earned her €700 a month. In today's money, this would be €945. Seda happened to know that in another department of her employer, in another town, there was a post advertised in telephone marketing. And that was because she had been offered that post in the past with a prospect to advertise the products to Turkish customers. When she asked to be transferred to marketing now, this was refused because her employer now wanted somebody speaking German without any Turkish or other accent. And they also dreaded the costs of retraining for data protection processing and word processing. So she was dismissed with effect to the 31st of January and Schadensbad in February 2007 before the Mönchengladbach Labor Court for three reasons. First, she said there was alternative employment. This is not a redundancy situation. Second, the employer hasn't complied with their obligations under collective redundancy law. And third, the notice period is way too short for a 10-year employment, which on statutory reasons gives a 4 months notice period and not just one. Before the local labor court, she won the first claim on the grounds that there was indeed alternative employment and that refusing to transfer her to telephone marketing was race discrimination because it was related to her accent. She lost the collective redundancy claim, and she also won the claim on the notice period. That wasn't as important because if there is no redundancy under German law, she is reinstated in her employment. However, it was just as well that she won the third case because her employer appealed to the regional labor court in Düsseldorf, which at the time wasn't exactly known for embracing anti-discrimination law. So there was no chance that they would support the race discrimination claim. So Kücükdeveci before the regional labor court only won on her last count with the notice period. And she would have been forgiven to think that the court didn't really act in her interest. She lost 2/3 of her claim, had to pay 2/3 of the costs, which were carried by a trade union, and lost her job. And as a woman of ethnic majority without a formal qualification, in the middle of her childbearing years, with 29 years, in 2007, when the economic crisis just started, she would have had difficulties finding a new post. On to the seminal relevance of the case. The regional labor court focused on section 622 civil code, which is about notice periods. It increases notice periods progressively from 4 weeks to up to 7 months, with increasing seniority. And Seda had 10 years seniority, which would have given her a 4 months notice period. However, there was a second sentence, which has been deleted since, stating that any seniority acquired before an employee's 25th birthday would be disregarded. And because Seda Kücükdeveci was 29, she only had seniority of 4 years, giving her a notice period of 1 month. So, in all honesty, one could have made a discrimination case beyond age on this. Seda Kücükdeveci was quite typical for a Turkish woman in the rural area at the time, starting employment rather early without a formal training, maintaining employment at the same employer for a long time, because without formal training, it's difficult to get another job. And the provision 622 of the Civil Code was made for other people, was made for the typical white male person who did a formal training, then gathered experience with several employers before they settled down in their mid-20s. So this would have been an intersectional case, and that would have been relevant under German anti-discrimination legislation because this provides for additional damages, for higher damages. But as I said, Regional Labor Court Düsseldorf not very interested in discrimination, or there was no chance they would accept this. They focused on the age discrimination aspect of section 622. And the first question was whether this is indeed age discrimination or justified. That's not so interesting. Clearly, it's age discrimination. The justification was thrown out by the Court of Justice because the argument that young workers would be encouraged to change their post more frequently wasn't really sufficient. The justification was thrown out by the Court of Justice because the idea that young workers would be encouraged to change posts more frequently by a notice period, which would only become relevant for them much later, was not credible. So the provision wasn't suitable to achieve the claim. The second reference question was more important. The second reference question attempted to question the Mangold decision. The Mangold ruling of 2005 was the first one which supported the idea that non-discrimination on grounds of age was a general principle of union law which applied directly in horizontal relationships. At the time when Seda Kücükdeveci was decided, a post-Mangold case was pending before the German Constitutional Court on the grounds that the Federal Labor Court had just applied Mangold without referring back to the Court of Justice of the European Union, again asking whether this horizontal effect isn't ultra virus. And so the Labor Court in Düsseldorf, the Regional Labor Court, asked, can a national labor court disapply a provision in a horizontal relationship contravening a principle of European Union law without referring to the Court of Justice of the European Union? And the Court of Justice did understand that there was a fundamental issue here and made a fundamental judgment saying, first of all, the national courts are union courts, and they are the ones who have to disapply a provision as a last resort. First of all, they have to try and interpret national law in line with union law. If that is not possible, and only if that is not possible, they might have an opportunity to disapply a provision of national law. In horizontal relationships, this applying of the provision of national law cannot respond just to a directive. However, the court confirmed Mangold, saying Directive 2078, which contains a provision of age discrimination, does not, in fact, establish the ban of age discrimination. Instead, Directive 2078 only confirms the general principle of European Union law, and that general principle is horizontally directly applicable. So this was a rather short judgment, and still one wonders, is there a legacy of this judgment? The court's webpage lists 83 annotations, and we find 32 rulings citing the case, 10 of which are by the Grand Chamber. And I've listed those on this next slide. And not all of these are, of course, equally relevant. In some cases, and that's the next slide again, the court only confirmed that equal treatment in employment is a general principle in Roma for sexual orientation and in figure for age again. It also underlined the relevance of interpretation and conformity in the Dominguez case, most recently in the Smith case, and reconfirmed that directives indeed have no horizontal effect, and Kücükdeveci is relied on all of this. So what is of more importance is the case law, which refers to disapplying national law without a prior reference to the court, because this is a continuing area of dispute. So in many member states, national courts, especially national constitutional courts, claim the authority to invalidate national law and do not think that the lower courts could disapply national law and achieve the same effect. So the Elchinov case on free movement, the Charico case on competition law confirmed this, and most recently in December 2018, the Minister of Equality case on non-discrimination law again. It's an Irish case where the question was whether the Workplace Relation Commission can disapply national law, although under Irish Labour Court, it's a Labour Court which invalidates national law if it conflicts with the Constitution and thus also with European Union law. So the court stressed the relevance of primacy of European Union law and the resulting obligation of any public body, whether that's an administrative body or the Workplace Relation Commission or a court, to disapply contravening national law without needing any authorization by the court or by a national institution. The direct horizontal effect of the ban of discrimination was reconfirmed in the AMS case of all cases. This is a French case, Association Médecine Sociale, where the court refused to recognize direct effect for Article 27 of the Charter of Fundamental Rights on Workers' Information Consultation. And here it referred to Kücükdeveci, saying this is a different situation where non-discrimination rights can be implemented by national courts without any further implementation, which isn't the case for discrimination rights. The D.R. Rasmussen case, decided in 2016, was one which fundamentally challenged Kücükdeveci. the Danish court wanted to achieve that it could retain its established case law interpreting Danish legislation as allowing to refuse those employees who are entitled to an old age pension employment protection, basically. And they also wanted to achieve that they could, especially in horizontal situations, maintain that principle. And here the court confirmed Kücükdeveci in the strongest terms and phrasing more clearly that the ban on age discrimination definitely will have horizontal effect, and conflicting national law must be disapplied without the opportunity to protect the trust and the legitimacy of that law. Conversely, at some times in the court also didn't use Kücükdeveci. The Spanish court in Grupo Norte facilities wanted to extend the ban of discrimination of fixed-term employees, and more specifically wanted to make this horizontally effective. And although the National Court referred to Kücükdeveci, the Court of Justice didn't, and also did not support horizontal direct effect of the ban of discrimination of fixed-term employees. In spite of the fundamental relevance of the judgment in Kücükdeveci, references to the case in Grand Chamber ruling have dried up. The Minister of Equality case decided in December 2018 is the last one. The reason for this is, in my view, that the court has moved on in relation to horizontal effects of general principles and puts much more purchase on the Charter of Fundamental Rights for the European Union. And this applies to anti-discrimination law, to the working time rules, and other rules as well. In the field of anti-discrimination law, the court's Grand Chamber now treats the AMS case, the one where horizontal direct effect of co-determination rights was refused, as a basis for horizontal direct effect of Charter Provision 21 on non-discrimination. And it is clarified that in the Eggenberger case decided in April 2018, that's case C/414/16, and this case was also about refusal to hire someone on the grounds mentioned in Directive 2078, in this case religion. And it was also the case whether the German Federal Court has to disapply an exception from the ban on religious discrimination. The court stated very clearly in this case that national courts are under an obligation, quote, to ensure judicial protection for individuals flowing from Articles 21 and 47 of the Charter, and to guarantee the full effectiveness of those articles. So the Grand Chamber refers directly to the Charter. And that's a step the Grand Chamber and Kücükdeveci hadn't done. Advocate General Bott, who did the opinion of Kücükdeveci, had written a very long and fundamentally well-argued opinion saying we should not succumb to the mainly UK orders to say directives need to have a horizontal effect. You should go a different route and use the Charter of Fundamental Rights of the European Union, which will have legal effect very soon. He wrote his opinion in June 2009, and base horizontal effect on that. But the Kücükdeveci Court, deciding in January 2010, when the Treaty of Lisbon was in force and the Charter had legally binding force as well, decided not to use the Charter. And that's the reason why this fundamentally relevant position decided not to use the Charter from that. I think I made it very clear. And that is the reason why Kücükdeveci will no longer be cited by the Grand Chamber in the same extent, which it deserves, because it indeed was a very fundamental decision.